Scarlett stood before the court, an attorney in a suit, swore an oath to tell the truth.
Welcome back to For the Defense. I'm David Oscar Markus, and wanted to start off by thanking you all for the great feedback over the past couple of weeks. I really appreciate it, and it's good to hear from you all. This week, you're going to love it. I think we have Gerry Goldstein, the man to see in San Antonio. I mean, this dude has been doing it a long time, and he still has the same energy and enthusiasm as he did when he started. Speaking of when he started, he had a case way back in 1974. It was the Deep Throat case. A guy named Richard Dexter, the film projectionist for that Deep Throat movie, was arrested 3 nights in a row. And you're going to hear about a prosecutor named Ted Butler, who was arguing that this film was morbid and shameful and obscene and trying to get Dexter put in jail, and how Goldstein represented him, calling experts and psychiatrists, psychologists, sex therapists who testified that this movie was just entertainment, humorous, educational. It's a crazy, crazy trial, crazy defense, and it goes all the way to the Supreme Court. I think you're going to enjoy hearing from my good friend, Gerry Goldstein, in For the Defense. Next. Well, welcome to the show. I'm really excited that we have the great Gerry Goldstein joining us today. Gerry is the man to see in San Antonio, but he's a close friend and a wonderful lawyer. So welcome, Gerry, to For the Defense.
Thank you, David, for those kind lies. Much appreciated.
Well, I want to turn back to a case that you handled back in the early 70s. Everybody knows the case as the Deep Throat case. Your client's name was Richard Dexter.
Yeah.
Where were you in your career when you got this case? What was the story?
I was just cutting my teeth. I had graduated from law school in '68. The film Deep Throat with Linda Lovelace and Harry Reams had come out in '72, and by '73, a youngster by the name. By the way, what was interesting is a lawyer in San Antonio who was originally sent the case. The case came from a Memphis lawyer who was the city attorney in Memphis, and he sent it to a very well-known lawyer in San Antonio who had, after he got the case, he was nominated for the federal bench, and he didn't want it. He didn't want anything to do with it, so he gave it to me. I didn't know any better. It involved go ahead.
No, I was going to ask you what it involved, and so you're early in your career, you get this call.
I'm a baby lawyer,
right?
Yeah, and I get a call, and he said, this kid Richard Dexter, who had gone to my high school, younger than me, was a dropout, and he was. He remembers this story a little differently than the court records, and I remember it. But in essence, he was looking for a job, and he went to the Texas Employment Commission, and they asked him what skills he had, and he really didn't have any, but he did tell them that he had run a 16 millimeter projector when he was in the military and in high school, and they used to show those syphilis films to the young students and airmen to convince them to engage in protected sex for a much different reason than we think about that today. They got him a job as a projectionist at the Fiesta Theater in downtown San Antonio in 1973. And for the next 3 nights, he was arrested for showing the film Deep Throat.
So he's just the projectionist, the low-level projectionist, and that's who they decide to arrest?
In those days, they never messed with the actual owners of the theater or the producers of the film. They went after the projectionist, and it was an interesting case for a lot of different reasons. And if you remember, Deep Throat was the first X-rated film that claimed it had a plot. I mean, you probably never saw it, but the opening scene is Linda Lovelace sitting in the sink, and she's smoking a cigarette, and she looks down, and Harry Reams's head is between her legs, and she takes a puff of the cigarette and says, "You don't mind if I smoke while you eat?" And that's the way the film starts. And if you think about this, Texas was a pretty conservative place, David, at that point. You couldn't buy a mixed drink. The Texas sodomy statute back before 75 made it a felony to place a non-sexual part against a sexual part for the purpose of sexual gratification. And I used to jokingly say that made me and Mr. Happy habitual felons before the age of 13. But it was an interesting time. There was war raging overseas. There were riots in the streets, much like we see today. Civil rights, civil liberties, free speech, free love were blossoming flower-like from their underground abode. It was a fun time to be a lawyer. I know you've got a lot of friends that are approaching my age, but I'm 77, and this was a great way to cut your teeth as a lawyer.
Well, one of the things I love is that you haven't slowed down one bit. You're going as strong now as when I first met you a long time ago, and I love it. One of the Gerry, one of the interesting things I read about the arrest, because they kept arresting him night after night, is that the lines for the movie kept getting longer and longer every time they arrested the poor guy.
It was the best advertising the film could have ever gotten. Speaking of the film, during the film, the judge turned his back to the film, and I finally objected. I said, "Judge, how can you rule on my objections if you're not looking at the film?" And the judge's reaction was, "Goldstein, I don't want to look at your dirty movie." This is in front of the jury. So
unbelievable.
Yeah.
So I'm gonna get to that in a second. Before I get to the trial part, when they first arrest your guy Dexter, I read that they did like the probable cause hearing in the theater itself. I had never heard of such a thing. What happened with that?
They actually watched the movie and made an initial obscenity finding. It was because at the time, obscenity had become a big issue. And I'll get to how big it was. But one of the interesting things was that you couldn't have a prior restraint. So what they would do is they would make a probable cause finding so that they could seize the film, seize the projector, put him in jail, make him make a big bond, and make a big deal about it. And the DA, a guy named Ted Butler, who's no longer with us, who became a judge, and we'll talk about that in a minute, but he was running for re-election. And what he was really wanting to do is to make a big deal out of it. And a commercial obscenity, even back in 73, it was a Class B misdemeanor. It wasn't a big deal. So he decided to charge it as a felony. And what he said was that there was a Texas statute, Article 1601, and he said that the use of the 16 millimeter projector was the use of a criminal instrument, which bumped it up from a Class C misdemeanor to a second-degree felony, carrying up to 20 years in prison. And it was an ordinary 16 millimeter projector.
Right.
And so we go to federal court. And in those days, you got a 3-judge panel to hear when you challenged a statute. And it turned out that, by the way, it was fun. There was a great elderly judge, Judge Singleton, out of the Southern District, multi-district 3-judge panels.
Right.
And I still remember we're arguing before him, and the young prosecutor, who also became a judge, is arguing the case. And Singleton looks at him and says, under your theory, if I wrote a dirty word with this pencil, I guess I'd be using a criminal instrument. You could charge me with a felony. And he thought for a minute, yeah. And Singleton threw the pencil at him. Shucks, it almost hit me right between the eyes. Anyway, we ended up before the 3-judge panel twice because they finally consolidated us with a bunch of other cases. And then we went to the 5th Circuit, and then we actually were heard by the 5th Circuit en banc twice.
Amazing.
they enjoin the prosecutions, which, as you know, with the Anti-Injunction Act and of 17, whatever it is, and the younger abstention doctrine, it's hard to get a federal court to enjoin. But our argument was, look, they're not never going to prosecute this guy. No, nobody would ever buy that argument. They're just harassing him, and they're repeatedly arresting him every night, making him make big bail, and seizing the film, and they're just trying to stop them from showing it before there's any trial.
And so eventually, though, it does go forward. I'm going to get to those appeals in a second. But, one of the things that I thought was really interesting was, they treated this as one of the biggest cases in Texas. They started searching the theater. They were on their hands and knees walking through the theater.
San Antonio police had cotton swabs, and they were on their hands and knees on the seats and on the floor trying to find semen. And we actually put on an expert who said, it's dark theaters that cause people to jerk off in the movie. It has nothing to do with what they're watching for the most part. They could do it to Bambi. But they did put us to trial, but it was the federal courts had stopped the felony prosecution. So they put us to trial ultimately after we go to the Supreme Court the second time on the misdemeanor offense. Actually, okay. In between the two times.
So you're going to trial on the misdemeanor. The case is getting tons and tons of press. And I think you mentioned you start hiring different experts. I read that some of the experts were psychologists to say that the movie was harmless, educational. I mean, how do you find these experts, Goldstein?
By the way, they were psychiatrists. Well, by the way, look, at the time, it was sort of like, what we're fighting right now over systemic racism. The idea was, you're going to teach my kids sex in high school? I don't think so. And there was a big stink about that. So the book that every high school used for sex education, there was a psychiatrist that wrote it. We called it. I won't get into the specifics of what the judge asked him in chambers, but he was a pretty good expert. I will say that he was the only one of our 4 psychiatrists they actually testified that they were not only harmless, but these kind of movies actually serviced couples that were having difficulties, that it actually was something that made their marriages better. But it's why I've always wondered about marriage counselors. Quite frankly, most of these psychiatrists had divorced their spouses by the time we even got to the case. But by the way, in the courthouse, the courtroom was packed. It was a fairly large county courtroom,
right?
And it was the DA's office would have passes so they could get into the courthouse before it opened. Well, you couldn't find a seat to save your life, and it was there every day for every minute of it. So
I want to ask you about that as you're getting ready for the trial, and you're trying to figure out what jurors you want to pick to judge this movie and this misdemeanor. How are you thinking about voir dire? What advice did you get about picking the jury?
My mentor and patron saint, a wonderful San Antonio lawyer, Maury Maverick. I've got to tell you about him. He's worth the story.
Please.
His great-great-grandfather was Samuel Maverick, who in Paul Revere's etching of the Boston Massacre, it's Samuel Maverick who's holding Crispus Attucks in his arms, and they both lay in state in Faneuil Hall after being executed. His grandson was Sam Maverick at the Alamo. He was a lawyer. And when William Barrett Travis had to send somebody to warn Sam Houston at San Jacinto that the Alamo was under siege, he sent Sam Maverick, because being a lawyer, he knew he could read and write. And in Willie Morris's book, Northwards Home, he quotes Maury Jr. saying, "That's the only time I'm certain education ever did anybody in my family any good." Anyway, Maury sat me down and he started talking to me about jury selection. And, as you know, and lawyers that try cases understand, you don't really select a jury. You discard jurors you don't like. You strike jurors.
Right.
So, when the judge says, is this your jury? I've never looked at it and thought, well, who the shit is that over at the end? It's the ones that don't say anything that end up on your jury, the ones that don't offend either side. Well, what he told me was, he said, go look at the nicest little old lady with blue hair, or, and question her and say, ma'am, Mrs. McGillicuddy, if you saw some woman with semen dribbling out of the side of her mouth, could you ever find that to be a socially redeeming film?
Oh my God.
And he said, you know what her answer is going to be. You're not looking for her. You're looking for some guy sitting behind her to the side of her with a smile on his face. That's the guy you don't want to ask any questions on and hope he gets on your jury.
What advice is that? That's amazing.
It was probably the best jury advice I've ever gotten.
Yeah, I'd say so.
Yeah.
I'd say so. Okay, so you get your jury with the guys who were smirking in the back.
Yeah.
I read the prosecutor gave this opening line for his opening, that the movie was morbid and shameful, patently offensive, and without redeeming social value. How do you combat that, Goldstein, in your opening? What's your opening like?
Well, my opening was fairly innocuous. It was talking about the need to have an open mind, something that in 1973, Central Texas was not really very appealing. But it wasn't that. I spent most of my time in the opening objecting to the prosecutor, because he wasn't just going ranting and raving about the terrible film. He continually, he pounded on the fact that this theater is owned by the Dixie Mafia. This is mob. The mob runs this theater. And he kept that up continually during the trial. I finally got the judge to order him not to do it anymore.
And I'll put a little asterisk there. We're going to come back to what happens with the mob part of the case, but you object, the judge issues that order. But then the next interesting thing that happens in the trial that I saw is that there's a big debate about whether the movie would even be played. And the judge lets you play it, of course, but as you said before, doesn't watch it, keeps turning around. And what I read was that the movie kept stopping in the middle of it. You can't play all the way through. What happens with that?
Well, what happened is they had put string into the little holes in the. By the way, it's a 60. It's not even a 35 millimeter film.
Right.
In the actual film in the canister, and it would cut it and it would throw it off the projector. And my objection was that the jury wasn't seeing the film as it was intended. Probably a break on our part, but the idea was that they should see it in the sense that it was meant to be shown, and that prevented that, because it would take them one day. It took almost half a day for them to put their film back together, even though they had seized some 6 copies of it.
They should have asked Dexter to help out get it to play.
He was a professional at that. And by the way, the funny thing about Dexter is. Where do you think he is now? He's a jury consultant in Dallas.
That's awesome.
Can you believe that? Yeah. And he looks very respectable.
I love it. I love it.
He's not that kid that we remember with the long hair. I made him wear a wig so the hair didn't go down to his tushy. Tell
me about that. In front of the jury, he wore a wig?
Yes. It was not a very good wig either. It was fairly, it was kind of like a helmet. It would wobble around if he got excited.
You couldn't get him to cut his hair, I guess. He had to go with the wig.
That was 1973. I didn't want to impose,
right.
a dress code on anybody.
Goldstein, I used to follow my dad around, who was a lawyer, and I saw him with a criminal case once, and he was appointed, and the kid walked in and had shaved eyebrows. It was the time where those kids were shaved. And my dad said, before the next time we go to court, you must grow your eyebrows in. And I was sitting there as a kid watching my dad yell at his client to grow his eyebrows in. And it reminds me of you having this guy wear the wig in front of the jury.
Yeah, it was a pretty stupid idea. Well, by the way, you couldn't come into court with long hair. So that was the obvious answer.
So you get the felonies kicked. The misdemeanor goes to trial. The judge is giving you this hard time. The guy, Dexter, gets convicted of the misdemeanor, but then, of course, you take it up. And one of the main issues on appeal, of course, is what you just talked about, this organized crime issue. Tell me what happens on appeal.
The case took a couple of weeks, I think, to try. And can you imagine that? I mean, the battle of the experts, and they had predominantly Baptist preachers, who condemned the film naturally. And so it even had religious overtones. But he kept going back to the mob and the mafia. And he had a big filing cabinet, one of those ones on rollers.
Yeah.
That he would roll in every day. And as you know, I've never understood this. There's nothing in the rules that says the prosecution gets to have the table right in front of the jury. But I don't care if federal or state court, they always get that table. It's like it's a designated thing for them to be able to hold up papers and look at them so the jury can look over their shoulder and see the conviction list or whatever they're looking at. Anyway, but he'd bring in this big thing, and I noticed for days the jurors kept on craning their necks looking at it. And finally I got up, and because he would bring it in before everybody got there, and he would take it out, and they were right up against almost, there was barely room for it in front of the jury box, but just enough that they could see it. And there was a big sign on it in big red letters, and it said organized crime.
This is the prosecutor's cart right in front of the jury.
The cart. And we end up, I had a conniption fit. I'm jumping up and down, and I will go over there and rip it off the thing, and I make it an exhibit, and I offer it into evidence, and I make a bill, the bill of the bill, and I offer it, and the judge accepts it, and it goes into evidence. And the Texas Court of Criminal Appeals, which is our highest, still our highest criminal court, it handles, as the Supreme Court handles civil cases. In Texas, the Court of Criminal Appeals handles criminal cases. Said the unanimous opinion, which I love, I still love it, says an accused is entitled to at least one tolerably fair trial. And obviously, the prosecutor in my case had violated the one tolerably fair trial rule.
What a great line, even from your Texas Criminal Court of Appeals, which I understand is not the greatest court for criminal defendants, Goldstein.
Well, that's the one that affirmed a death penalty when the lawyer had slept through the trial. And they said, well, maybe that was his trial strategy.
That's great. That's good. So you're entitled to at least one tolerably fair trial. Tolerably. You mentioned this. I got to go back to it, that the prosecutors always get this table closest to the jury, so that people listening know. So there's two tables, of course, facing the judge, and typically in courtrooms, the prosecutor's table is the one closest to the jury, and the defense is the one furthest away. And it always drives me crazy. When I was a public defender, I said, you know what, I'm going to beat the prosecutor into court and just sit at that table and see what happens. And they were freaking out, and they asked the judge to have me moved, and the judge ordered me to move to the other table. And I said just what you said, like, what rule is that? Yeah.
And by the way, I think you know a Houston lawyer, wonderful lawyer named Ed Millett.
Yeah.
And we used to try cases out in Judge Wood, and the federal judge who was unfortunately assassinated, but out in Del Rio. And there was a little prosecutor who, by the way, was put in the witness protection program because there was an attempted assassination of the prosecutor as well. Not anything we had anything to do with. But the prosecutor was small like Edward, and he had kind of a squeaky voice like Edward. And the court reporter, who used to use fountain pens instead of a stenographer, and he was pretty good, by the way, pretty good.
Yeah.
But shorthand. And he used to ask me to give him a signal as to which one of them, because he couldn't distinguish their voices. They were two squeaky voices. But anyway, one time, Edward goes to court early and sets all of us up at the prosecution's table. And the prosecutor comes in and said, Your Honor, Mr. Mullet's over there. Look at him. He's got my seated at the prosecution's table, the U.S. attorney's table. And, we said, well, Your Honor, there's no rule. And then he said, now, gentlemen, and Millett had anticipated all this. And he said, please, let's not have this trial start this way. Let's have collegiality. And so Millett and I get up and we move the other table. And Millett had gone and unscrewed the balance thing on the back of those chairs that go back and forth. And the guy sits down at it. It flips him over backwards. And the two of them chased each other around the courtroom. It was brilliant. It was absolutely brilliant.
I love it. I love it.
Yeah.
If you and I did that today, we'd be in shackles.
Yeah.
Those were better times, I think, to try cases. So you win on appeal. You get this tolerably fair trial. You had previously won on the felony, and there's a third case that ends up going all the way to the Supreme Court.
Well, it went there the first time where the city of San Antonio and the state appealed the three-judge en banc Fifth Circuit. And then, think about this, by the time all this happens, it's 1976. And if you remember, this was a 1983 action that we had brought, or skirting around Younger, and obtain a judgment. And during the time that was all happening, the Civil Rights Attorneys Fees Awards Act of 1976 gets passed. And so we then filed for attorney's fees, and the state takes that up to the Supreme Court. So the second case that we get is the Supreme Court saying, no, they're entitled to it. And they even, you probably know this, the standard was in those days was fairly decent. They looked at it as though it was a sophisticated federal case, and they used the same indexes that they use in a SEC case, and we've set up a free speech section for the ACLU, and donated the fee to them, which really pissed the state off.
How much was the fee?
It was a whopping $20,000, but that was all right.
That's pretty good. That's pretty good.
In 1976, that when I went to work, when Chris and I got married 53 years ago next week, I was making $10,000 and her tuition was $4,000. And by the way, I had just as much fun, perhaps even more then, as I do now, but I'm still enjoying being a trial lawyer. I still enjoy going to court, still enjoy the fun.
Well, Goldstein, with that $20,000, you could have gotten a new bus to drive to the Supreme Court. Tell me about this story. So you get to argue, Dexter's case in the Supreme Court.
When it was 1969, it was what I was telling you, and we had this VW bus. We had taken all the seats out, put a Persian carpet down with pillows all over, a big PC symbol on the back of it, Ramsey Clark for president on the bumper sticker.
Love it.
And we got run out of more South Texas counties than you can imagine. But it's fun that in France they were that interested in this series of trials that went through the federal appellate courts all the way to the Supreme Court twice.
So great. Goldstein, you have been a big advocate for criminal defense lawyers, for the right to trial. You've done a lot of work for the First Amendment, for marijuana. How do you have time to do all of this stuff and keep going?
It's what you enjoy. It's the same reason you go to trial, I think. And by the way, it's a fading art, David. I worry. When you look at the federal court system, if you don't think America can build an efficient railroad, you've never seen the criminal justice system in action. 97 to 98% of our cases are disposed of by pleas. And the trial penalty is a big one. And that really started getting worse once we started getting minimum mandatory sentences and the sentencing guidelines. They coerced people. It wasn't worth risking the minimum mandatory. And the sentencing guidelines created this, the idea that judges had discretion to individualize sentencing it made that a really important part of everybody's practice. I think it's too easy. Most of the judges now have never had that discretion. It's too easy to say, look, I'd like to help you, but my hands are tied. I've got to give you, whatever it is.
So
go ahead.
It's terrible. And that's why I'm doing this podcast, to talk to great trial lawyers like you, to try to inspire some folks to do more trials, because that's why we became lawyers. I mean, that's, to me, why we're doing it.
Absolutely. And there's a little twinkle in our eye. You've got to be a little bit of a theatrical person and a little bit of an anarchist. Not much, but there is something fun about dealing with holding the government to its duties and obligations. And that's why I worry when lawyers say, well, I wouldn't represent somebody. I'm represent mainly these days white collar crimes because that's where the money is. But to be honest with you, we represent, murderers and child molesters. And I don't think it's the lawyer's duty to circumvent the criminal justice system, to say, I'm not going to represent you because I think you're guilty. I'm not going to represent you because I don't like the facts of this case. When we do that, we short circuit the system. We default to the lowest common denominator. We have an obligation, I think, as trial lawyers, to put our client's best foot forward. It's not that long ago, the Supreme Court reminded us that even guilty people have the right to effective assistance of counsel. I think that was Kyle or one of those cases. It's important that we understand that our job is not our job is not to decide the ultimate issues. It's for two lawyers on either side to advocate for their clients and to use the rules of evidence and exclude that which is not admissible, to introduce that that is. And if you got two good lawyers on each side, you're going to get a fairly just result. Amen.
And so, that's why this case was so important, I think, because it showed that even a small-time projectionist in Texas could ultimately prevail and get fees. And you told us, that Dexter ends up becoming a jury consultant. What ends up happening to your prosecutor and your judge in that case?
Well, I'm not telling any stories outside. The prosecutor became a judge, and he was found dead of a heart attack in a motel room with his secretary. The lead prosecutor, the one that insisted on Chad Butler, the one that came up with concocted this idea that a projector could be a criminal instrument. He became a state judge. Interestingly enough, there's an article in Nation magazine where, after the Fifth Circuit had chastised him in their en banc decision, the Carter administration withdrew their nomination for him to be a federal judge, or he resigned, withdrew that nomination when that happened. Interesting. And by the way, I was excused from having to practice before him. People used to hire me just so they wouldn't have to go before him, I think, at least.
That's a great way to market.
Exactly.
Hire me, you don't have to go before this judge. You can get him recused.
Yeah, it was sort of like, after Dexter got arrested the third time, you couldn't get into the theater. It was so packed. But interestingly enough, Judge Butler, who was actually a nice guy in many respects, he ended up in a assisted living for dementia patients with my mother, and was in the room next door. And I always worried that he might remember me when I would walk by.
That's funny. So I have to ask you, I'd be remiss if I didn't ask you about one of your clients, a totally different case, but one that everybody always associates with you and asks you about, Hunter Thompson. I need a good Hunter Thompson story before we finish this, Goldstein.
He was harder on his friends and his lawyers than he was on his enemies. I can tell you that. I still remember after we won the first case and the DA moved to dismiss the charges, the front page of the paper read, that was an act of cowardice, and I've instructed my lawyers to appeal immediately to the Colorado Supreme Court. But I can tell you that he was always fun. I would go out to Owl Farm, and it would be one night it'd be George Plimpton. You get to talk about sports, and the next night it'd be a nude female motorcycle gang from Louisiana. It was always a surprise, and he was a good friend and a difficult client, as they mentioned tomorrow.
Sometimes the best of friends make the most difficult of clients.
I think so. I think so. But you're a delight, David.
So Goldstein, before we finish, any advice to young lawyers about getting started in criminal defense, trying cases? What's your advice to them?
I think it gives you the opportunity to understand and realize that our founding fathers really did understand something about this. Our system is flawed. I'm the first guy that will bitch about the Justice Department and the judiciary, but I'm part of that system, and it works better than any other I've ever seen. And we don't use it enough, and it's gonna dry up if we don't. I think it's important for every young lawyer to think about the idea of standing up in courtrooms and bar rooms and classrooms, and standing up against injustice whenever and wherever it rears its ugly head. It's a privilege to go into courtrooms and do that. I'm still enjoying it at 77, and I encourage all of my brothers and sisters, when they come into this fold, come join David and I. We'll have some fun.
Amen. I love it. Amen is right. How cool is Gerry Goldstein, the man to see in San Antonio, and really just a wonderful trial and appellate lawyer throughout the country. It was fun to talk to him. He's just an energetic, enthusiastic, always positive guy, and you can't help but get excited and energetic when you hear from him and when you talk to him. And that's what's great about Goldstein. Love working with the guy, love speaking to him about the Deep Throat case back in the 70s. And he's always around at all the different conferences. And he's one of the guys that everybody gravitates to because he's so much fun, lovable, and smart as a great lawyer. Anyway, thanks to Goldstein for doing that episode. We'll be back in 2 weeks talking with Jeffrey Feiger about the Jack Kevorkian trial, fascinating euthanasia trial that you all remember. Talk to you in 2 weeks. My name is David Oscar Markus, and this is For the Defense.